Good morning and good afternoon, everybody. I spent almost 30 years as a deputy district attorney in San Diego County, and for about 10 of those years, I was working on body cameras and technology and digital evidence. And I know that 10 years ago, when body cameras first came out and started to be deployed in earnest, there was initial reluctance by law enforcement to wear them. And now we're at the point today where they're practically ubiquitous, and a vast majority of the officers and deputies wear them, and they are eager to wear them. With widespread acceptance, we've seen a lot more videos, a lot more evidence coming to our courtrooms from the officers. Virtually every single case that makes it to the district attorney's office and to court has some form of body-worn camera evidence in it. Today, we will look at the use and impact in court. We will hear from the perspective of a deputy district attorney, a defense attorney, and a judge to gauge all aspects of how body-worn camera videos have impacted court hearings as well as trials. At any point in time, if you have questions, please ask, and I will look to incorporate them. And if not, we'll ask them at the end of presentations. I'm going to ask each of the panelists to introduce themselves and tell us a little bit about themselves, and then we'll get into our question and answer. Joel Madero, Deputy District Attorney from San Diego, why don't you go first and give the prosecutors introduction?
Good morning, everyone. My name is Joel Madero. I work with the San Diego County District Attorney's Office. I'm currently assigned to our catch unit, which is our high-tech unit. So as many of prosecutors out there probably know, there aren't a lot of attorneys in the prosecutor world or even criminal world who kind of nerd out on the tech side of what we need to know. And so my unit focuses on crimes where technology is either the target of or a major component of the crime itself. I do have a full caseload, but on top of that, I run a criminal lab here, a forensic lab, and then handle the tech side, including presentations such as this. Thank you.
Thank you, Joel. Peter Will, a Senior Deputy Public Defender from San Diego, if you could introduce yourself and tell us a little bit about yourself.
Sure. Good morning, everybody. My name is Peter Will. I've been a public defender in San Diego since 2005. Since 2016, I've been a supervisor for a team of approximately 16 felony lawyers and 2 paralegals. And this team handles anything from garden variety felonies all the way up to murders with special circumstances. Body-worn cameras are a daily part of our life at work.
Thank you. And finally, we'll hear from Judge Ricardo Rigual from the Virginia's 15th Judicial Circuit Court.
Good afternoon, everyone. I'm Ricardo Rigual. I'm the judge, as you said, in 15th Judicial Circuit of Virginia, which is starts about 50 miles south of Washington, D.C., and is about 50 miles north of our capital in Richmond, Virginia. The circuit court is the court of general jurisdiction in Virginia. It's the highest trial court before you go on appeal. I've been judge of the circuit court for 8 years now, and before that, I was 5 years as a general district court judge. We see quite a bit of body-worn camera. It's really pretty common now. Almost every case that's tried has, to some extent, body-worn camera footage involved. It's my pleasure to be here. Thank you.
Thank you, Your Honor. So I'm going to ask each one of you the same question. I'm going to vary who starts with the question. This time we're going to start with Peter. And Peter, if you could discuss the early challenges when you first got body-worn camera evidence, 2014 and 15, and how it was impacting court proceedings, and then how you dealt with the influx of evidence over the time.
Yes, well, it was a major change. And speaking in terms of the courtroom impact, the first thing that comes to mind, I would say, is that body-worn camera was turned over initially, as I recall it, on a CD. And part of the problem was that when you wanted to use the CD in court as an exhibit, what would happen is it would be laggy or slow to load. So it created a gap between the movement and trial and maybe the presentation of the video. You know, it might skip, it might take time to queue up. There was also a lot of stress among the lawyers about how do we obtain all the body-worn camera evidence. If we're going to use them in court, they're going to need to be transcribed. Do we have the personnel or the budget to get everything transcribed? And also, you know, the body-worn camera, it provides a voluminous amount of material, all of which isn't necessary in trial. So it would be a challenge to, say, clip and adjust and manage the body-worn camera, you know, kind of refine it until it's ready for trial. And that includes redacting it and getting the clips and pieces that you want. These were all challenges that the lawyers I worked with faced day in and day out as we made this kind of sudden shift into the world of body-worn camera evidence.
Joel, if you recall when you were first, actually probably as a newer DA in getting body worn cameras, not all your cases had it, but eventually they did. Why don't you tell some of the challenges that you faced early on?
Yeah, there was certainly some overlap from what Peter was just talking about. But I think that immediately what I noticed was it doesn't end with body worn camera. It really was an ecosystem change. We needed hardware support and software support to handle what was coming in. Early on, we were trying to figure out exactly what tools we needed from, TVs in every courtroom and kind of the movement of all of that. As far as discovery and the impact on what we do in court, what I would see often is, especially being in like a pretrial readiness department, the amount of continuances that we were having early on because of we don't have the body. Either it was defense saying we don't have the body worn camera, or alternatively, it was just you shared 100 different things on a 3-count complaint, and now I'm going to have to spend 20 hours reviewing all of this on a single case before I can even negotiate a case. So I'd say early on, it was certainly the volume created delays. And then I would just second a lot of what Peter said as far as while in trial, dealing with the flow and kind of how to play the videos was really a challenge, and teaching our attorneys kind of what was really necessary versus what we might be able to not. There was a lot of expectation of you have body worn, so you must need to play it. And that's probably an ongoing issue that we have. But at some point, it's just because you have it doesn't mean that you have to play every single second of every single body worn camera in front of your jury. So yeah, that was early on days what I would say.
Your Honor, thinking back to the beginning of body cameras coming into Virginia and seeing them in your court with the practitioners coming in and presenting it, what challenges did the court face, or what types of things impacted your position in the courtroom and how trials went?
In Spotsylvania County, where I sit, the sheriff's office relatively recently, about 3 or 4 years ago, adopted, purchased and outfitted the entire sheriff's office with these body worn cameras, and that the use of these body worn camera really coincided with a significant change in Virginia law as it relates to criminal discovery. So about in 2020, Virginia completely changed its discovery rules as it relates to criminal cases. Before 2020, the defense attorney was really in the Wild West. You really got almost nothing, depending on the jurisdiction. Let me say this, you were legally entitled to almost nothing discovery other than your client's statements. So this created a big problem on the Commonwealth attorney's side, the prosecutor's side, in with meeting their obligations for Brady, for example. There was a legal ethics opinion that came out that said that they had to review every second of any body worn camera. And this was so significant that it actually delayed the implementation of the discovery change from 2019 to 2020. So initially there was a lot of problems related to time and resources that needed to be implemented to make sure that they could comply with the rules of discovery, to review the cameras, to produce Brady material, and to make it available to the defense bar. So it was pretty significant, but it seems to have gotten, it's a little different depending on what jurisdiction you go to, but that initially presented a pretty significant challenge.
Thank you. Peter, turning back to you, thinking about how you overcame those initial challenges with CDs, transcript, money, redacting. Tell us about how you worked that out in your office and what you've heard from other defense attorneys, not only in San Diego, but in other parts of the country.
Say directly what lawyers started doing in court is that they would have a CD with the body worn camera that they want to present. They would then mark the CD, it would be an exhibit. However, then they would play the body worn camera directly off of their computer, which is much quicker, right? You're not loading up and queuing up with a CD. It's not ideal though, because it's not the true exhibit. And, God forbid, it's not exact as to what's submitted with the court. So I know a lot of lawyers would have what they need on a CD. They would present it as an exhibit and then play off the computer. That's kind of the way that they manage that. And I think another solution that is coming into play is lawyers are trying to lodge flash drives with multiple pieces as the exhibit, and then they can use that, the actual exhibit, which should move with good speed and much better than a CD, and keep the courtroom moving smoothly. So I think those are some of the ways they were overcoming kind of the lag that a CD provides. It's still a little bit cumbersome. I would say that we also have a transcription team that we've developed. So right now we've built up a transcription team in our office. So the lawyers are encouraged to obviously review the body worn camera very quickly if they can, and then to identify what's going to be used in the courtroom. And then we give it to our transcription team who works tirelessly because you can imagine they're getting requests from every which direction, but they work tirelessly to put a transcription together so that it will be admissible in court. Lawyers have also been trained on an app, I believe it's called the Photos app, where they've learned to kind of cut pieces out of the body worn camera to kind of cut it down to size. Part of the agreement we have with the DA's office, there is a stipulation that we've worked out in terms of the rules of engagement, so to speak, when they turn over body worn camera. Part of that is that, you don't reveal any personal identifying information, when you display the body worn camera footage or if you have to show it to a client, et cetera. So the lawyers are also learning to kind of use this app to redact certain things out that are legally required to reduce the size to what is exactly relevant for the courtroom. But it is cumbersome and time consuming. Body worn camera is extremely time consuming for the lawyers. For example, a simple call regarding a vandalism or something that's not very serious, you might have 8 or 9 officers respond, right? And each one turns on their body worn camera, and maybe they're involved in about an hour of work there, right? Now you're talking about 9 hours of body worn camera footage, just like that. It has an exponential quality to it that leaves a ton of work for the lawyers involved. And there are certainly benefits to it, but the increased workload and stress and demand on the lawyers is definitely a detriment. So we're working through that because it is important evidence.
With respect to your transcription team, they don't transcribe every video you receive. It's the ones where the lawyers have identified that they're likely to need for a court hearing or a trial. Is that correct?
Yes, absolutely. We're very clear with our lawyers that, look, identify just what you need so not to, make their heads explode, so to speak, because they are working very hard. So the lawyers do a great job on my team, at least, to kind of narrow it down and be very precise in what they want. And then the transcription team will provide the transcription. And then, when it goes to a court hearing, they will bring in the exhibit along with the transcription explaining that, hey, I'm intending to play this in front of the jury, and here is the transcription ready to go. But yes, they tailor it to exactly what is needed.
Thank you. How did your office, or how did you actually overcome them? You're higher tech functioning than a lot of people, but what did you see in terms of, you talked about ecosystem discovery, continuous delays? What has changed, or what has not changed, I guess, and how have things improved?
Sure, happy to talk. If I could just, it's interesting hearing Peter's perspective, obviously from a defense side. So I will certainly answer that particular question, but I wanted to respond to, I see things a little bit differently from the prosecution side, just because it's our burden in front of a jury. And so when he's saying they're focusing on using the least amount possible, which is a good approach to efficiency. On our side, I think we always worry about, well, we don't want our jury to think that we're hiding something. And so oftentimes we are making decisions to maybe show more than we otherwise really feel like it's necessary, or maybe sometimes even feel is relevant. I have certainly had juries where I've cropped and done decisions because I thought it was the most efficient way to move forward, especially in my misdemeanor days. I'm like, I don't want to spend 2 hours watching body worn camera on this misdemeanor. And then after I either have a hang or a not guilty, and the jury's like, well, we wanted to see the full body worn. And had they seen it, it would be lots of officers doing nothing, right? Because that's what we see so much when we're reviewing this stuff. And that's something that it's hard to tell a jury, don't worry about what you didn't see, because it probably wasn't relevant because nobody played it, not defense, not prosecution. So we should just all move on. But going back to the kind of some of the highlights of our early days here, my office was very forward thinking. We have a couple attorneys here that kind of saw the horizon. And I know Damon used to be in the office, but we have several other attorneys also. We made large purchases in tech to make things more seamless. And so we have iPads that are available for use with our trial attorneys. They're really easy to check out, not a lot of questions. It's just, I'm going to trial, I need an iPad. That has some software that we have licenses for. I believe it's called TrialPad. And that, as far as playing and kind of interacting with an Apple TV, that we largely, in our branches at least, we have 5 locations here in San Diego, central, and then branches. In our branches, we have large TVs that we kind of know in each department where to put. We have Apple TVs to stream to. So we have the iPad, which will stream our body-worn camera to the TVs. That all made it better. Not to say there aren't still some hiccups, especially in the branches. One thing that we constantly are talking about is the internet going slow or down. That's, I mean, in 2024, it drives me crazy that we are in these large buildings that's, we lose the internet in the middle of a jury trial, and for whatever reason, it stops interacting with Apple TV, and now we're having to go up to backups. And we see, I guess from an efficiency standpoint, as Peter was talking about, like I myself, I will prepare my trial pad, and then I have my backup PowerPoint still. And so that's doubling my work. And it's very difficult to have kind of to transfer everything into the iPad the way it needs to be transferred. And then while simultaneously trying to think of actually being an attorney and asking questions and kind of how this trial is going to go forward, simultaneously being like, okay, well, now I have to prepare a second exhibit methodology in the event that something like our Apple TV stops working. And that, I'm going to be honest, it has made me a little gun shy about using the equipment to the extent that's possible, just because for me, if I see a hiccup in court during a trial, immediately I'm like, oh, is the jury getting frustrated with me? Is the judge getting frustrated? Central is very different. And so we also have a forward-looking court as far as we built a new courthouse somewhat recently, I guess in the last few years. It's very high tech and it's very seamless. And so you bring in your system, you plug it into an HDMI, it projects it throughout the whole courtroom. The audio is great. So it's nice to have our partners on the court side provide that, both I think for us and for obviously the defense side. So those are largely how we dealt with kind of the ecosystem, is looking at what other products could we use to make this more seamless. And I'd say largely it's been successful. We were ahead of the curve as far as implementing body-worn camera. It's been years and years that we've been using body-worn camera throughout San Diego. We've ironed out most of the issues at this point.
Joel, you mentioned something about jurors wanting to see video. Do you see that your lawyers try to get some type of video to play so there's, because everyone has a camera, just to introduce something into court, even if it's not relevant because the policing was reactive, not proactive?
100%, I would say it's almost a default mentality of there's this media, we need to figure out a way to play it. The best advice I ever got from a team leader when I was in misdemeanor days was, I have a 1-count misdemeanor DV domestic violence charge. Just go forward with 0 tech. And I did that. I did a close without tech, no PowerPoint, no nothing. And I think that made me realize it doesn't always have to be the case to use the media. That being said, I still get nervous that if I'm going to play the media, am I just, even though I'm only interested in 3 minutes of a 45-minute video, am I playing the whole thing? Just because I don't want my jury to think that I'm hiding the ball, and then weighing that against a judge getting irritated, saying, "What are we doing? We're watching, we're watching a ton of unnecessary body-worn footage." And my response can't be, "Well, the jury might have questions if I don't play it." That doesn't make it relevant, I guess.
Your Honor, how are things overcome? You talk about the delays initially in Virginia with the change of the law, kind of combining with the increased use of cameras. How did things overcome, and you continue to push cases forward and get cases to trial?
The solution, unfortunately, where we are is it depends on what jurisdiction you're in. So the attorneys that practice criminal defense work in this area really have to practice in multiple courts. They, probably 4 or 5 different counties, and the solution on each one of those depends on the county, because they have their own sheriff's office, they have their own Commonwealth Attorney's office, and the solutions that they come up with can be very different from jurisdiction to jurisdiction, which makes it even more challenging. Here in Spotsylvania, we're quite fortunate that the county upgraded its tech in the courtrooms before COVID came out. So, and it works great. So we're really lucky about that. But the different ways they've overcome it, a lot of it comes down to cooperation between the Commonwealth Attorney's office, the prosecutor's office, and the defense bar. They got to be willing to cooperate with one another to make things available. Here in Spotsylvania, the Commonwealth, will either burn a DVD, they'll give a thumb drive, they'll actually give that information, the body-worn camera footage, after they find it, to the defense attorney, whether it's public defender's office or somebody who's in private. Multiple jurisdictions are using different websites. There's one, they've given me a couple of names. There seems to be one in the area that a lot of the jurisdictions are using, where the sheriff's office will download the body-worn camera automatically to this website that the attorneys have access to. There are some difficulties with that, unfortunately, as well. Sometimes you're not able, for example, to download it from the website, depending on what settings they have. There are other, issues with just some, from a defense perspective, some offices are better than others at getting them the information timely, which sometimes creates a problem. The most important part is the cooperation, which I think there are rules of discovery now that make it clear on what has to be given to the other side. It has really clarified a lot, and it has encouraged cooperation between the two sides, so we don't have any issues. Now, as far as the presentation, I mean, a couple of people have mentioned the presentation in court, whether you want to play an entire 2-hour video from different perspectives or it should be edited. I am very much on the side of this, it should be edited. I try to encourage that. But again, that takes a lot more cooperation between the two sides. I mean, if you've ever seen a jury, start eye rolling and blank out when they're seeing a sheriff's deputy waiting for backup to show up, then I think you should understand that. I mean, it needs to be edited, but again, that takes cooperation. That takes planning, depending on jurisdiction and what kind of technology that they use to record and store the cameras could create a lot of problems. For defense attorneys, I spoke to one today, as a matter of fact, about it. Sometimes they don't have the software that's compatible with what the sheriff's office uses to record and store their body-worn camera. So they spend an hour, just trying to figure that out or downloading it from some other areas. But as far as overcoming those, it depends on the jurisdiction.
Joel mentioned, trying to get videos in or play something of a video. Do you have a rule that it's just not relevant to what's going on, that these videos, because sometimes the videos just don't, I mean, you talked about a deputy waiting for backup. Have you ever just said, no, I'm going to exclude it because it just doesn't have any probative value?
I try not to jump in and tell people how to try their cases and let them do that themselves. What I do is, if they have a dispute on what should or shouldn't be played during a jury trial, then they'll usually, the first step is to try to work it out themselves. But if they can't, I'll ask them to file motions in limine so we can take a look at it, determine what is or isn't admissible, and make rulings before you come to trial. And you're sitting there making a jury wait in the back room for an hour while you resolve some dispute about what should be admitted on a body-worn camera or not.
Damon, you mind if I just reply to that really quick? Because I have.
Oh yeah, go ahead.
So yeah, I think that's an interesting point as far as I think from a judge's perspective. I think also from, I'm sure defense has probably a similar perspective as prosecution, is that we go before a court, we file our motions. Every motion now has something about body-worn camera. I think it's just a default motion that goes inside of our in limine motions. But our courts, as I'd imagine throughout the country, are very impacted. So we get a ruling from a judge that says, fine, of the 15-minute video that the prosecution was planning on putting on, play the whole thing, but you're going to have to redact, and picking very specific things to redact throughout. Now we have a jury waiting for us, and we're being told right now we have to find a way to get in contact with support staff here, or sometimes some of the prosecutors themselves will say, okay, I will ask, give me 30 minutes and I'll try to handle this myself. But that creates kind of what we're trained to do as criminal attorneys is to go forward and try a case. And so getting a ruling that dramatically changes the way that we are going to be presenting a case because of certain redaction decisions, or you can't play it at all, you have to clip things a certain way. It creates the instead of focusing on your opening, your witnesses, all of these things, instead your mind now is, oh, I have to comply with this order. And then you have the follow-up of the judge telling you, well, now you also have to tell your witness, who you've prepped and you've gone through the body-worn camera and you've let them see kind of, this is your statement. So this is probably what or the officer, this is, I distinctly remember resisting a peace officer case that I took to trial that, we went through this body-worn camera over and over again, just kind of walking through it. And then there are decisions that you have to then take telling your witnesses, don't talk about those things that you're going to be watching the body-worn camera, but then it's going to go mute for a while, or it's going to be like, it's going to jump 2 minutes. It creates pressures that I think already being a trial attorney is a lot of pressure. And it just adds to that need to be kind of, for lack of a better word, distracted with kind of the ancillary things going on. And then you play the video and you're just crossing your fingers, the redactions were what were requested. And I've certainly been in trial before where I thought I got everything, and all of a sudden a little bit goes off, and I know right away, I was supposed to, that was not supposed to be there. And you get the looks from the court, you get the objections from defense that are all part of this new era of having this amount of body worn camera involved.
That's why the motions practice is so important. Encourage them to look at these things. Don't wait to the last minute. Come in before the trial, get your rulings, and then you can be ready to go, and the trial runs much smoother. But inevitably, those problems sometimes come up during the course of the trial. Came up the other day, as a matter of fact, when someone invoked his right to remain silent, and there was an objection to that, and we had to deal with that on the body worn camera, domestic case.
Yeah, that would definitely play a role in that. Joel, I'm going to start with you on this one. What are some of the more innovative ways you've seen body worn camera videos being used in either motion practice, hearings, prelims, or trial? Any part of actually in court?
Sure. So starting with, like I said, our trial pads were the first innovation, and I'm sure there are other tools out there that are being purchased around the country, but just really having a very seamless way to be going from questions to having something in your hand to where you can just push play and it pops up on the screen, and you don't have to really pause, go to a computer, push play, and it's just the seamless aspect. We're good at that, and I would say it's innovative compared to what I'm hearing is happening throughout other jurisdictions. But beyond that, I'm seeing, and I have done this personally, is transcriptions on screen. That is something that, for those of you who have not done it, I know, I'm sure everybody in this room is probably super busy, and it is very time consuming to do. But there are free tools out there that are available. I've certainly done it myself, to where putting your transcript, instead of having a paper transcript, obviously for your jury, is at least here the norm. I believe it's a rule of court, but also having it up on the screen, because what I see when I'm putting on a trial is, you have somebody looking down at paper the whole time and not focusing what's on the video. And so I distinctly remember I had a child overdose case. It was a toddler who had overdosed on fentanyl. And obviously when law enforcement arrived, it was a very powerful scene, very sad scene. A law enforcement arrived, there's a child who's presumably dead on the floor. And I was really worried that if I printed out these transcripts and I just told them to look at the transcripts, they would miss the video. They would not focus on the video. And so I actually used some freely available tools to put the transcripts on. You have to make lots of decisions and editing decisions. Again, things that most attorneys are not trained to do. And I spent plural hours making sure that the font, like kind of watching through the video, it would stand out, but it wouldn't block what I wanted the jury to be seeing, and kind of the size of the font, depending on how far you were going to be from the screen. Lots of decisions were made. Ultimately, that case resolved. The child did survive, so I wanted to point that out, that they were resuscitated. But that was something that I think that we have a few people doing, but not many. And I do think it adds a lot to the presentation aspect of a jury trial. And then timelines. I've seen some very innovative use of multi-angle timelines, that you have the best video audio playing, so you can hear everything, but at the same time, you're seeing the scene from lots of different angles. And I've seen it done to where I'm imagining we are very fortunate here in San Diego. We're a very large prosecutorial agency. We have a lot of support. So I've seen where you'll hear kind of the change in perspective, because the trial attorney has made the decision, like at minute 5, body worn camera 1 is no longer the best audio. Now it's body worn camera 2, and you'll hear the transition. And I think it's an extremely powerful way to present a case, in particular, I think for closing, that just letting somebody see the same serious crimes happening from lots of different angles, but always having the best audio, kind of as a trial attorney, what you want your jury to be hearing is really powerful. And sometimes, once the exhibits go in the back and they're with your jury, they're going to be watching it individually. They're kind of making their own decisions on what to focus on and what to mute, what not to mute. And when you do that, you take some of that decision making out of their hands, and you kind of are like, this is what the prosecutor, feel like is the best evidence to put forward. So I've seen that done really well, actually. So that's kind of what stands out there.
So Peter, you have a lot of young attorneys who I know are trying very serious cases. What type of innovative things have they deployed or employed in court, and or what have you heard about because I know public defenders throughout the state and other parts of the country do talk. What is the conversation about being innovative or using the videos in a way that really helps you?
Well, I have a couple of examples, but first I want to second what Joel said. I think that people are doing what he said, where, again, you'll have a group of officers respond. So a scene is viewed from multiple different angles, and each angle provides different important evidence. And we have been able to kind of stitch together kind of the best pieces so there's kind of a seamless flow, for a closing or something, so that they can see the narrative that we see, put together in a way that's easy to digest. So I think that is something that has been very effective. Now, are we trained to do that? Absolutely not. We're all thumbs, it seems, when it comes to that stuff, but we have put together a unit within our office called TSS, Trial Services Support, and they are a group of very tech savvy individuals. And, I'm consulting with them on the regular, but if we need their assistance, we put in an action request within our internal data management system, and then they will assist. For example, this is common, but one lawyer used it. If there's an important scene with a bunch of people moving around, trial support services has been able to kind of identify or highlight an individual in a color or with a number, and it'll track that person as they move through a complicated scene so the jury can keep their eye on that person. Additionally, they may slow something down and put a circle around it, zoom in, and allow you to follow this item with a green circle, so to speak, so you can keep your eye on the ball. Those types of things have been very effective. There's one lawyer I spoke to who pointed out a way that she used it very effectively. And this is a case, it was an arson case, and there was an acquittal. And the lawyer played body-worn camera from multiple officers for the jury. And there were many, many people captured, civilians that were there, witnesses, that were not spoken to by law enforcement. And she would go through each one and she would use it on cross-examination and say, did you speak with this person? No. Did you speak with this person? No. Did you speak with this person? No. So there were all these questions that needed to be answered, yet there were dozens of people at the scene that weren't spoken to. It was very powerful, and it resulted in an acquittal for our client. So those are some of the ways that I've seen body-worn camera be very powerful for trial presentation.
Fantastic. Your Honor, you get to kind of observe, you're a neutral observer making decisions and watching the prosecution and the defense play things out in court. What has struck you? You get to see it firsthand. You haven't lived the case, you're seeing it there. What types of things have you seen? It's like, that I really like, that was good.
Yeah. Well, first of all, let me say how impressed I am with the way the other Peter and Joel using their tech with the highlighting and transcripts and all that. I mean, as far as having I haven't seen a lot of that in this jurisdiction. I'm not sure why, whether it's just because it's new or it's just not as advanced as they are. But I mean, the seeing the written word go across the screen, I think is great, because a lot of the quality of the voice isn't, or the sound system inside the courtroom. Sometimes it's pretty difficult to understand what exactly they're saying. So I'm really impressed by that and zooming in. I've seen the innovative use that I've appreciated the most in two areas. One, during trial, and this example came just a couple of weeks ago on a DUI. It was a felony DUI. It was a third or subsequent, which elevates it in Virginia. Is the use of, and someone you all have mentioned it already, is the use of multiple angles. And it was used very effectively in this case by the Commonwealth, but also, also the defense side too. Because usually what you'll see in a body-worn camera is you focus on the main investigating officer, and that's really what you're seeing most of. And when you have the different angles, in this case, for example, you could, in the side angle, you could see the person swaying more than you could on the direct angle from the investigating officer. So it was used very effectively to observe the things that the investigating officer may not necessarily have seen, because they're focused on different things. You're going to hear the smell of alcohol in a DUI case. You're going to see the glassy eyes, the smell of alcohol, the slurred speech, those things. You're always going to see that. But some of the more subtleties, when they're asked to move from one area to the other, you see a heavy step or something different than what the officer is paying attention to. So that was very effective from my perspective, seeing it for the first time. And I was seeing things that the Commonwealth wasn't even talking about, or the defense wasn't talking about. I thought that was very interesting, and I wouldn't have been able to do that without the use of multiple angles from the other officers that were present. Now, on the pretrial motion side, I think it's amazing. I can't tell you how many motions to suppress I've argued and that I've heard. And until the last couple of years, I've never actually been able to see the chain of custody from the search to the seizing of the material, to the bagging of it, to the putting it in the car. So I was able to evaluate the chain of custody when there was an objection, not just from the description that the police gave, that the sheriff's office gave, but seeing it on video, the whole thing. And a lot of the question, I was very impressed by that. It doesn't happen in every case, but more and more of that is being captured now. So you're not just relying on the testimony of a sheriff's deputy or a detective or someone like that, which on the defense side, often questions. You're looking right at it and you can see what's going on. So those are the two areas that I've really been impressed with the most.
Fantastic. All three of you talked about multiple views. And I know, Joel, you were talking about some of that being used in a closing setting, not necessarily playing as evidence because it'd be hard to authenticate each one separately if they're different cameras. Had the opportunity to see or employ having 4 or 5 videos playing where they move through the scene, because we have maybe a surveillance camera here, a ring camera, 2 officers, things like that, and then play the scene out that way?
Yeah, I have certainly seen, especially, when we're talking about homicides and really serious cases where a lot of investment of resources are being used. We also have a TSS here. And so that's when we get them involved and kind of clearly lay out. Lining up the timeline could be a little difficult, but once that's resolved, I think it's incredibly powerful to it's hard to really show a jury the totality of a crime from the before to the after. And with the amount of video evidence out there, you can oftentimes patch together. And then you can even have, I've seen it to where you have the timeline simultaneously with a map, like a Google map that shows where they are. I've seen this for like a 2800, so that's a felony evading of a law enforcement officer in a vehicle. And you see kind of the vehicle on video, and then above you see it tracking inside of a Google map. And so you can really, if you're in the area and our community members here, our jury, they can really start seeing like, oh yeah, I know where that corner is. Okay, I'm following, I'm tracking along. I can understand what's happening. I know there is in fact a stop sign that was blown there on the corner. And storytelling is half the job, and I think it is incredibly powerful storytelling when you can really lay it out on video like that.
Both of you mentioned TSS, and I take it that those are non-DA, non-sworn people with technical experience, probably trending towards a younger side. Our Snapchat, Instagram generation who are really good at immediately putting the videos together. And do you either, I know you go to them and bring them what you want. Do you ever actually bring them in earlier on and let them tell you what might be good, using these, in essence, civilians to help you put your case together, not just from the tech side, but from the concept side? Peter.
Yeah, I think so. I might bring them in and say, hey, here is what I have. Here's what I'm going for in kind of a general sense. I want to project this. I want to, get these points or these ideas across to the jury. And I will consult with them, and they might say, hey, maybe we could do this. We might be able to do that. And it'll kind of be a work in progress between the both of us in terms of, okay, how can we best achieve that goal with, my legal knowledge and their technical knowledge. So we work hand in hand often. And now if something's been done in the past and it's specific, like maybe a circle around an item and track it, something like that, and I know that's what I want, I might just be very specific and say, hey, can you do that for me? And that'll get done. But there are other times where we certainly collaborate. What is the best way to make this digestible for the jury? And they're very helpful.
Yeah, I agree. And oftentimes what I have found, being and I'm going to say the prosecutor bubble, and, we practice our openings, our closings amongst our colleagues. And at some point, many of us have a frame of reference to kind of be grounding ourselves in when we're listening to an opening or a closing and kind of how the presentation is going to go. I use TSS for that, honestly. Sometimes when they come down and I'm walking through and I'm thinking about options and getting their opinion, I'll actually start doing my close and say, this is kind of what I'm thinking. You tell me. And many of them, you're right, Damon, many of them are younger, haven't been in the office as long, and have a different life perspective, which, our jury is composed of everybody in our community. So it has actually not only helped on the developing kind of for presentation purposes, but it has also sometimes resulted in me actually tweaking my openings and closings because I'm like, oh, I thought it was, A plus, brilliant, going to persuade everybody. And then, you have somebody who's 23, 24, who does not have kind of all my preconceived thoughts of how a trial should go. And they're like, yeah, that didn't work at all. And all right, that video is not nearly as powerful as you thought it was. And I'm like, oh, okay. So I think that's incredibly helpful and useful on both ends.
Fantastic. So I have two more areas I want to talk about. The first one is going to be, let's talk about the challenges that you currently see or anticipate as we get more and more digital evidence, not just body camera, but all digital evidence. And again, not necessarily just what we feel by way of an office, but more how it's going to impact courtroom hearings and proceedings. Peter, I'll start with you. Judge, I apologize for going last with you, but it seems to make most sense because you're the end user and some of this doesn't quite hit up directly. But go ahead, Peter.
Yeah, I spoke with a senior attorney not long ago, and he felt that one of the challenges that he faced is that, there's inconsistency in the courtrooms in terms of what judges will allow. And there are some judges that will allow what he believed to be a lot of inadmissible hearsay in through the back door, not enforcing redactions and just saying, hey, this stuff is coming in for context of what you're intending to bring in. And there's some frustration there in terms of some courts will do that, other judges won't, and that's just part of the practice, I suppose. But that is one of the challenges. Another challenge is the increasing amount of digital evidence. I mean, I talked about a simple crime like a vandalism where you might get 6, 7, 8, 9 officers. What about something more serious? When you're talking when we got a homicide or something in that realm, you might have 25, 30 officers respond. Everybody's got a body worn camera on. The amount of body worn footage to review is tremendous. And then on top of that, right, the body worn camera footage is in high definition, right, and it takes up a tremendous amount of storage space. Where do we put all of that? For every case coming in, we got cases coming in every day, and there's usually at least a couple of body worn cameras associated, even with misdemeanors, all the way up to dozens with more serious cases. And where do you store it, right? It's in a tremendous amount of video that needs to be stored. And we have a duty to maintain that stuff. We have a duty to maintain the file. So that is another issue that does arise. Also, I'd say ensuring that deputies or police officers start their body worn camera footage early enough. So the way the body worn camera works here is that when the officer hits the button, right, it'll capture 2 minutes prior to when he hits that button, right? So you will get 2 minutes before he actually presses the button, which is good. However, it doesn't include audio in that 2 minutes. The audio starts exactly at the time the button is pressed. So many times we will see an officer on the scene talking to somebody in a critical moment, and we get no audio, right? And the audio comes in after 2 minutes, but there's been a conversation already, maybe first responding, and that is critical information. You'll never get that audio back. So I think it's important that the officers will, hit those buttons as early as possible because it can be really frustrating. And I understand there's stress, they're responding, there's a lot of things going on. To the extent it can be trained in as almost instinctive, and I think we're getting there, that, earlier is better. If I have to watch 2 minutes of you driving in your car before you get there, that's fine. I just want to make sure I hear everything that happens when you arrive. Another lawyer expressed some concern about not necessarily just body worn camera, but in the realm of all digital evidence, because we're getting more and more of it, a concern about AI generated fake videos and things of that nature. So, for example, they are so effective and so real, it's hard to tell what is real and what is fake for some of these things. And, if we're pulling things off of social media, some type of post, can it be authenticated? How do we prove if it's real, if it's been modified? So those are some areas of concern going forward in terms of these quote unquote deep fakes and things that may be out there. And, in this day and age, a lot of the material that we collect comes off of social media. So, is this stuff authentic or not? Will experts be able to tell if it's authentic or not? So those are just some of my thoughts, generally speaking.
Joel, your thoughts?
Yeah, I just have a couple quick ones. So I am actually quite deep into AI stuff. And so I just did a panel last week. I agree on that front that that's going to be an ever growing issue. Now, I actually see it even different, or a little bit more, a bigger problem, because I think there's already tools out there where AI is being used to clean up video, to alter the original evidence. And oftentimes knowing when that's happening and how that's happening and what that tech is doing is very difficult to figure out. So obviously the deep fakes and stuff like that, I've seen some horrendous technology that's already available, but it's also just an attorney thinks, like they go online and they're like, how can I make this particular grainy video better? And then they put it through some AI tool that is actually modifying the video. And they don't really know that. It's not on purpose. It's not. And so they don't even think to tell anybody about it. They're just like, oh yeah, and now it looks much, much cleaner. But that's not the evidence. And so that is a concern of mine, that just as these AI tools grow. And then I agree entirely with the sheer volume. It's becoming both as a cost, efficiency, all of this. It's incredible how much digital evidence there is, and how to manage that is a full-time job in of itself. And that's something that I do here in my catch unit, and it's a lot.
Your Honor, what kind of challenges do you see for the court with the future of more and more digital evidence, not just body cameras, coming in to the courtroom, either being played and or part of the record, and how you store that? What are your thoughts?
Yeah, so I agree that the volume is really becoming an issue with cases, particularly the more serious cases. Like we have, for example, your cell phone. I mean, the amount of data that's used from the cell phone, and everything from the cell phone towers, location information that the FBI has a special unit that analyzes, GPS movements, geofence information, text messages, downloads, and you take that and you combine it with the Ring cameras that they were able to canvass for. We had cases where defendants came down from the north in Philadelphia and committed a pretty serious murder down here. So you had that matching up with the toll booth camera that catches the vehicle coming through. That's matched up with the data location, which is then matched up with a Ring camera across the street when the car comes. So the volume is definitely an issue. Our experience in what happens in court and how we introduce those things is something very similar to, I think, someone else mentioned. Usually the Commonwealth will have the exhibit, the disc, the thumb drive, something there that'll be admitted into evidence, and then they'll play it from their actual laptop or something that's been edited or is cleaner to use during the course of a trial. That seems to have worked so far. Some of the problems that we anticipate or will still be facing is, and it's just starting to happen now with all of this video, and depending on the scene, you could have a bunch of people standing around, yelling things, talking to people, saying things that may not be admissible. So having to deal with what comes in and what doesn't come in, hearsay issues, depending on both sides have issues with this sometimes, and the importance of trying to go through that in advance and really get some rulings on it if it's necessary. But dealing with what is and isn't admissible in the video can be an issue. Also, more in a more practical way, because we have so many jurisdictions and the level of their sophistication with this stuff varies. I was speaking to just today, actually, when we finished court, I asked a couple defense attorneys and the Commonwealth's attorneys there to stay after and just have a brief discussion about the kinds of issues that they're having from their perspective, and how that comes into court. Is something as simple as a jurisdiction in this area asks the defense attorneys to come in and watch the video in their office. And you can imagine when you have, you want your client with you when you're reviewing this. Obviously, from a defense perspective, you want your client there. And trying to have a discussion about their defense based on what's on this video can be very difficult. So confidentiality issues are big, particularly on the defense side, when you're forced to come in and view a video and you don't have the privacy that you need to do those things. And sometimes it's just because of the level of sophistication that they have, or you can't play it on your laptop because you don't have the latest version of whatever browser you need or to be able to deal with it. So admissibility, volume, and some practical issues surrounding confidentiality and delivering the product to the people that need to see it are the things that I see that are going to continue to be difficult going into the future.
Thank you, Joel. So this is for all the panelists, excuse me. One of our attendees has a follow-up question as to what we were talking about, challenges. I'm not 100% certain anybody can answer this, but I'm going to put it out there. What is your experience or advice? And that's where I'm a little concerned about. So we'll focus more on experience, particularly for Your Honor, for getting a recording into evidence when the officer's unavailable. So the officer's not there, maybe he's deceased, and getting a video in. Again, I'm just looking for experience, not advice. That way we stay within that framework. If anybody wants to weigh in.
I think that the real hurdles actually. So my experience has been, if there's an unavailable witness, I mean, if it's hearsay, it's hearsay. And I'm trying to think of a single time that I've been able to play a video with hearsay statements in it. And I've heard of just recently our office had a dying declaration that obviously was able to play, but without an exception to the hearsay rule, that video is probably not coming in.
I think from my experience, it probably ends up being a plea agreement on my end rather than a trial if it's serious enough. That's my impression, because they don't really involve me in the problem beforehand. Or sometimes to justify a plea agreement, they'll say, well, we had some, quote, evidentiary issues, and that's really all they need to say. If I could just say one general thing, though, about the use of videos, and this is a lesson I learned a long time ago, because we're going to see more and more of this. Be careful what you play. I had a case years and years ago. It was a shoplifting case. I was convinced that my client was going to walk out the door based on this great video of where I was focusing my attention on that was very important to my defendant. And well, what I'll say is that everyone who watches a video sees something different because there's so many things that you need to pay attention to. I'd say before you decide to use a video in court, make sure that you've watched it over and over and over again from different perspectives. Try to think like the other side, because you may be surprised on what the judge notices. In my case, a judge noticed something that I really didn't want him. I hadn't even seen after watching the video several times. So just be careful what you ask for.
Happened to me more than once.
Damon, I could also speak to this too briefly. I have seen in my experience where if it is an officer responding and it's an ongoing emergency, sometimes that'll come in as a spontaneous statement, so long as the video could be authenticated. But the moment that situation switches to, the ongoing emergency is contained and now the officer is moving towards investigating and solving a crime, the moment those questions become testimonial, that's the end of the road, because now it's going to be inadmissible hearsay. We don't have the right to confront and cross-examine, right? But maybe some of the earlier pieces during an ongoing emergency have been admitted because they're not testimonial and they can qualify as spontaneous statements. That's been my experience.
So I'm going to give one final comment on that, then I'm going to turn it over to John Markovic for final comments and thank yous to everybody. I would imagine that if multiple officers roll on the scene, you might have a chance to at least authenticate some of the video that way. If somebody saw him take his camera, the policy says to play the video, turn your camera on. Somebody saw his camera on and someone saw him dock his camera. I think there's a better chance of potentially, but it sounds like it's most likely one officer on the scene, in which case I think we run into the other issues. But I'll leave it like that. We really can't, that's going to be individual jurisdictions and things like that, but there are ways to try at least. With that, I'll turn it over to John.
Just quickly, I'm John Markovic, and I'm the Senior Policy Advisor at BJA. I oversee the body-worn camera program. So first of all, thanks to Quinn for putting this together, for Damon for facilitating, and for our three panelists for really providing some great insights and giving us the generosity of your time. I have to say that this is the furthest that we've really dived into the prosecutor's defense and really touched on the court's experience with sort of being exposed to body-worn camera video. And then, as Damon mentioned, that's only a part of the puzzle. There's all sorts of other digital evidence that is increasingly being integrated. I think the judge's example was great about in the murder case from Philadelphia about how these pieces need to be integrated. So I think that's actually the other thing for me is it's sort of vindicated my decision about, our enabling legislation has really started with providing funding for the purchase of body-worn cameras, but we pushed the envelope a bit in 2022, and we created some demonstration projects around how police can share the digital evidence, but also on how prosecutors can best leverage and use this evidence. So we look forward to learning from those sites. And based on what I heard today, I'm going to try and rack my brain into seeing if there's a way that we could fund courts in optimizing their, the way that they use body worn camera, being able to cope with the volumes of body worn camera, but also being able to showcase on how to optimize the use of the body worn camera. With that, I don't want to take us too much over time. So thanks again to the panelists, to Damon and to CNA for putting this together. It's really a fascinating discussion.
Thank you, everybody. Have a good day.